In the past 2 years, we have seen some of the greatest assaults on our voting rights since the Jim Crow era. Ernest Montgomery is a councilman in Calera, Alabama. Calera has had, like many jurisdictions in the South, a complicated racial history. In recent years, there was an attempt on the part of Calera officials to redistrict their jurisdictional lines such that the one African-American candidate would not be able to compete in his seat, notwithstanding the fact that he enjoyed large-scale public support. The jurisdiction of Calera attempted to move forward with its improper and illegal drawing of lines, but the Voting Rights Act, Section 5 specifically, prevents them from making these changes until they get approval from the Department of Justice. They didn't seek approval.
I think the redrawing of the districts was done in order to eliminate the only African-American councilman that we had here in this city. And after the redrawing of the district, Mr. Montgomery ended up losing the race.
The Department of Justice came in, blocked the lines, and Mr. Montgomery was able to be elected when they were done in a fair process. When Shelby County as a whole decided to challenge the constitutionality of Section 5 of the Voting Rights Act, he and others intervened in the lawsuit to help defend the act. And he, along with his lawyers and other interested parties, are going to be the voice of the voting rights community when the Supreme Court hears the case on February 27th.
Section 5, in my opinion, has been a safety net. You know, it's been something that has forced people to do the right thing. I know in my heart that Shelby County and even the South is not ready to have Section 5 removed. And if this Section 5 is removed, I'm afraid that, you know, the Old South will rise again.
The Voting Rights Act is supported by everybody on the Shelby County Commission. We believe in it. It's sections 4B and 5 that we quarrel with constitutionally. Sections 4B and 5 require, using a coverage formula that's 48 years old, require that any covered jurisdictions, which are some 16 states and approximately 12,000 cities and counties throughout the country, to have pre-cleared by the Justice Department before they implement any act at all that pertains to elections, whether it's forming a volunteer emergency medical district, whether it's moving a polling place from one church to another across the street. You have to go to Washington, D.C. and get it approved if you are a covered jurisdiction.
The Voting Rights Act is one of our country's landmark civil rights laws. Section 5 is sometimes called the preclearance provision of the Voting Rights Act. And what it does is that it targets certain localities that can be states, they can be counties, they can be smaller jurisdictions than that have a particularly egregious and demonstrable history of racial discrimination in voting. Without Section 5, one of the most effective tools that we have to prevent politicians from being able to manipulate the rules of the game to keep minorities from participating will be eliminated.
I think we've proven that the South has changed. We're not the same South we were in 1964. We don't have the blatant discrimination that we had in 1964. And our attack is simply based on the fact that Congress did not have a sufficient congressional record to establish that there was any intentional discrimination in the covered jurisdictions, or that it was more than in the non-covered jurisdiction.
I think that the battle has always been fought from the perspective of the black church. You know, when you think about what the civil rights and, you know, movements that took place in the South, I think it always began with the church, with the preacher and our religion. And I think that the fight continues, and I think that it has to continue from the church's point of view.
A just government, like the church and the family, is one of the institutions ordained by God. And we are not being good stewards of that institution if we allow it to be infected by racial discrimination.